Hello, everyone, and welcome to One Civil Law. And for today's story, we're turning our attention to a case that was recently granted cert by the U.S. Supreme Court. And so we're going to be hearing this case and talking about this case a little bit. So this is recently granted cert in the case of Oklahoma versus Drummond. The question presented is whether the academic and pedagogical choices of a privately owned and run school constitute state action simply because it contracts with the state to offer a free educational option for interested students, and whether a state violates the First Amendment free exercise clause by excluding privately run religious schools from the state charter program solely because those schools are religious, or instead can a state justify the exclusion by invoking anti-establishment interests that go further than the First Amendment establishment clause requires. All right, so let's translate that from Supreme Court into English. All right, Oklahoma has public schools, and they also have schools that are not necessarily public in the traditional sense of the word, or at least they're state funded, and we're giving them money, okay? We're giving them money. And some of these schools are charter schools, which are, sort of public, or they're public, I suppose, but not in the traditional sense. And there's a lot of advantages and disadvantages to that based on whatever, metrics you can have. So you sort of have three kind of categories, right? You have your traditional public school, you have your charter school, which is public, but funded in a different mechanism and created differently. And then you sort of also have private schools that receive governmental money. And so it might be said to be state actors within some sort of domain, okay? So we have two questions presented. First, we have a private school that contracts with the state to offer free educational options for interested students. So it's a private school, privately funded, people give it money, and but they have a contract with the state that says, we'll give you a free option. We'll give the student a free option. Presumably the state is paying for it, right? So does that constitute state action? That would be a problem if that was a religious school. Okay, would that be a problem? Issue number two, we've got this charter school that says we're just a flat out religious school. We're a religious school, and we'd like to be a public religious school. We'd like to be a public religious school. Now, can they do that? Well, under First Amendment principles, the answer would typically be yes, provided that the state was making that available to all kinds of religious schools, right? Assuming that they made it available to all kinds of religions on equal terms, then that should be fine. Then we can cite lots of cases for that proposition. But Oklahoma went one step further. Okay, Oklahoma by its constitution says we don't want to fund any religious schools. We don't believe in it. We don't think it's okay. We don't want to fund any religious schools at all. All right, so it's like, well, can they do that? Can the state of Oklahoma say we don't want to fund religious schools? No matter what, we just don't want to give any public money to any religious schools. We want completely out. Can they do that? So that's sort of the question presented, which is an interesting question. And so we're going to read this case in the case of Drummond versus Oklahoma on this question. And to do that, we're going to read the decision from the Court of Appeal, from the Supreme Court of the state. So we're reading the Oklahoma Supreme Court's decision on this issue, which will, of course, turn on state law and some federal law issues. So we're going to read this. And it's also noted here that this is interesting because the Oklahoma Supreme Court took this case up on original jurisdiction, which, state law, you do you, right? State law, you do you, right? So apparently under state law, it is possible for the state Supreme Court to, under this circumstance, be the trial court. So that's what we did. We skipped right to the head of the line. And the Oklahoma Supreme Court, this is our case now, yoink, we're the trial court. Sure, fine, no problem. Each state can define jurisdiction the way it wants, and so that's what they did. So the state Supreme Court of Oklahoma is like, we're the trial court now, I am the captain, and we're proceeding forward. Great. So let's read a decision from the Oklahoma Supreme Court that tells us a little bit about what's going on in this case. The Oklahoma legislature has a constitutional duty to establish, of course, Oklahoma speaking about itself, so they're going to be focusing a lot on Oklahoma. The Oklahoma state legislature has a constitutional duty to establish a system of free public schools. In 1999, the legislature enacted the Oklahoma Charter Schools Act to help carry out this duty. Under the act, a charter school is a public school, sponsored by entities such as a school district, technological center, regional institution of higher education, federally recognized tribe, or the State Board of Education. So we have some traditional public schools, and then we've got this newfangled kind of public school, that exists outside the normal system. We call it a charter school. Great. Charter schools use innovative methods and a form of accountability, provide academic choices for students and parents, and offer different professional opportunities for teachers and administrators. However, the Act requires that all charter schools be non-sectarian in their programs, admission programs, policies, and other activities. So the state legislature is like, we can have these new fun alternative public schools, but they can't be religious show. They can't be religious public schools. That's what the state legislature said. Great. Moving on. The Archdiocese of Oklahoma and the Diocese of Tulsa applied to the charter board program to establish that St. Isidore, which is a religious St. Isidore, a religious virtual charter school. St. Isidore does not dispute it's religious. Instead, it says it's to create, establish, and operate the school as a Catholic school. They are not hiding the ball. They are not hiding the ball. It's like, we'd like to have a public school that is a Catholic public school. That's what we'd like to have. Can we have a Catholic public school, please? Great. Specifically, it plans to derive its original characteristics and structure as a genuine instrument of the church and participate in the evangelical mission of the church. We are going to try to convert people to Catholicism. Our school is Catholic. We'd like to convert people to being Catholic. Being Catholic is awesome. Would we like people to come to our school and learn a little bit more about how being Catholic is awesome? Okay, so they're not hiding the ball. The Charter State Board is a state body with the sole authority to form virtual charter schools. On June the 5th of 2023, the Charter Board voted 3-2 to approve the revised application to become a virtual school. So the state board that reviews such things says, we're cool with that. On October the 9th, the Charter School Board voted again 3-2 to contract for sponsorship. St. Isidore was created with the government as its sponsor. On October the 16th of 2023, the parties executed the contract. The St. Isidore contract commenced July 1st. So the state entity that's responsible for the creation of these schools says, your Catholic religious school sounds totally cool to us. We're perfectly happy with that. Go forth into the world. A virtual charter school authorization and oversight manual provides the model template for the program. However, the Charter School Board can negotiate contract terms that add to or vary from the contract if terms comply with applicable law. So there is a standard contract, but they're allowed to modify it as long as they agree and as long as it otherwise complies with law. Cool. The St. Isidore contract, as you might anticipate, varied significantly from the model contract. So we're going to create something that is very bespoke. The St. Isidore contract recognizes that certain rights, exemptions, or entitlements apply to St. Isidore as a religious organization under state and federal law, including ministerial exception and aspects of church autonomy doctrine. All right, so ministerial exception is an exception that applies in hiring practices. It basically says, I'm sure you well know, it is illegal to discriminate on the basis of religion in hiring. You can't discriminate on the basis of religion in hiring. And churches were like, but we really, really want to because, we're churches and stuff. And so the Supreme Court has opined that this thing called the ministerial exception, in order to make it compliant with the First Amendment, right? In order that the Civil Rights Act be compliant with the First Amendment, what we're going to say is the Civil Rights Act with respect to discrimination for religion does not apply to ministers. And long story short, ministers relate to core aspects of the church as church, but don't relate to the aspect of the church as not church. So, for example, if you're hiring someone to work in your soup kitchen, okay, and all they do is make the food, that's literally what they do. They work in the soup kitchen, they're behind the scenes, they don't really talk to people, they make the soup. That's what they do, okay? And you're a church. Can you discriminate on the basis of religion? No, okay? You're allowed to have your soup ministry. You can do that, and it can be religious in its nature. That's fine. But the employee in the back, what do you care? All he does is make the soup. That's what he does. So you cannot discriminate, church, in the hiring of the people to run your kitchen. but you can discriminate in hiring of people to run your ministry. Makes perfect logical sense, and that is the rule. Great. So they say that there's ministerial exception, which would allow them to discriminate on the basis of religion in terms of hiring, and aspects of church autonomy doctrine. The St. Isidore contract does not contain the model contract section entitled Prohibition of Religious Affiliation, because that'd be really dumb. Instead, the St. Isidore contract states that St. Isidore has the right to freely exercise its religious beliefs and practice consistent with religious protection. Under the model contract, a charter school must warrant it is not affiliated with a non-public sectarian school. In the St. Isidore contract, Isidore warrants that it's affiliated with a non-public sectarian school or religious institution. Cool. Due to the nature of the St. Isidore contract, the state seeks a writ of mandamus, so someone's pissed, presumably the Attorney General. The state seeks a writ of mandamus directing the charter school board to rescind the contract. The question before this court is whether the contract violates both state and federal law. We hold that the contract violates Oklahoma's Constitution, the Act, and Federal Establishment Clause. St. Isidore is a public charter school. The Act does not allow for the charter school to be sectarian in its programs, administrative policies, employment policies, and operations. The Act's mandate is in line with the Oklahoma Constitution and the Establishment Clause, both of which prohibit the state from using public money for the establishment of a religious institution. Again, I'm not really sure that's exactly what the case law says when it comes to such issues, assuming that they're doing it on an even basis. But okay, that's what they say. St. Isidore's educational philosophy is to establish and operate the school as a Catholic school. Under both state and federal law, the state is not authorized to establish or fund the school. All right, fine. So we're going to discuss a little bit about Oklahoma law, and then we'll discuss a little bit about federal law. Now, of course, as to the Oklahoma law, the Oklahoma Supreme Court is God. Right? As to Oklahoma law, the Oklahoma Supreme Court is God. The U.S. Supreme Court cannot overrule the Oklahoma Supreme Court as to Oklahoma state law. All it can do is say that decision as to what the law is conflicts with federal law. So you have to take the Oklahoma state law as a given. You can then say it conflicts with federal law, but you can't modify the decision as to what the state law is. So here is what it says, at least in terms of Oklahoma's Constitution. Article 2, Section 5 states the following in Oklahoma's Constitution. No public money or property shall ever be appropriated, applied, donated, or used, directly or indirectly, for the use, benefit, or support of any sect, church, denomination, or system of religion, or for the use, benefit, or support of any priest, preacher, minister, or other religious teacher or dignitary or sectarian institution as such. The objective in construing the Constitution is give the framers' intent as well as the people applying it. Our court discusses the framers' intent in drafting Article 2, Section 5, wherein we held the placement of the 10 Commandments on grounds of the Oklahoma State Capitol violated this prohibition. The court concluded that although the state did not spend public funds to acquire the monument operated for the use, benefit, or support of the religion. Okay. The concurrence also noted the framers were religious men who stayed their proceedings during the convention with prayers. However, they recognized the necessary of complete separation of church and state and sought to prevent the ills that would befall the state if it failed to provide for complete separation. So they want complete separation of state in Oklahoma, which as a matter of state law, of course, is their prerogative. As contended with the amicus curiae, this Prescott court also wrestled with whether it's a Blaine amendment by stating, in spite of the court's filings, which conclude that the Oklahoma Constitution is a Blaine amendment, nothing in the history of this reflects that. So we will skip past that. The framers' intent is clear. The state is prohibited from using public money for the use, benefit, or support of a sect or system. Although a public charter school, St. Isidore is an instrument of the Catholic Church, operated by the Catholic Church, and will further the evangelical mission of the Catholic Church. And of course, the school does not deny literally any of these things. They are saying, yes, all these things are true. The expenditure of state funds from the operation constitutes the use of state funds for the benefit and support of the Catholic Church. It also constitutes the use of state funds for the benefit of a sectarian institution. The St. Isidore contract violates the plain terms of the Constitution, Oklahoma's Constitution. Enforcing the contract would create a slippery slope and what the framers warned against, the destruction of religious freedom, which, as far as the language of Oklahoma's Constitution goes, I would tend to agree. I mean, the language of Oklahoma's Constitution seems pretty strong on this point. So I think that they're reading their own words correctly. The Oklahoma Constitution also delegates the legislature the constitutional duty to establish a system of schools. The Constitution of Oklahoma mandates provision shall be made for the establishment and maintenance of a system of public schools which shall be open to the children of the state and free from sectarian control. So again, like the Constitution says, no religious schools, yo. You got to have schools. They can't be religious. The legislature enacted the act to help carry out this duty. Under the act, the charter school is a public school sponsored by a governmental entity. Yeah, I mean, I have no problem drawing that conclusion. It's a public school. That's fine. Use any test you like, right? Use any test you like. This is pretty governmental action, guys. This is pretty governmental action. It's like we can get into the finer points someday about whether a private entity is acting as the government or not, and whether the First Amendment therefore applies to said private entity. This is not one of those cases. We don't really have to get into the weeds. It's the government, yo. The act prohibits the school board from sponsoring the religious program or charter school program that's affiliated with a non-public sectarian school or religious institution. Our court has defined sectarian institution as a school of institutional learning which is owned or controlled by a church, which is avowed and maintained and conducted so children of the parents of the faith would be taught the school religious tenets of the school. Well, that's pretty freaking on point. Like, you know, we're not having to really dig too deep into the case law here. It's like, this is pretty on point, right? There's no question. This is a sectarian school. All right. So if we needed to have a discussion about whether the obviously public institution is a public institution or not, well, let's discuss that. So is the church school the government? Is the church school the government? The Charter School Board and Isidore contend that the Oklahoma Constitution provision requiring the system of public schools be free from sectarian school does not apply to St. Isidore because Isidore is a private corporation and not a public school. Yeah, no, I don't think so. They further argued that despite its sectarian nature, the St. Isidore contract does not violate the Oklahoma Constitution or Act because St. Isidore is merely a private actor contracting with the state to perform a substantial benefit for the state. Yeah, but that benefit being public schools. So, yeah. Again, I'm not really sure that we really have to do a deep dive into whether or not the private institution is really the government or not. Sometimes it can be hard to tell. This is not one of those times. These cases are distinguishable from the facts before us. In Morrow, the court held that state funds paid to a sectarian institution in exchange for housing and care of orphans discharge did not violate this law. However, the court specifically noted the institution had sectarian character as an organization, as management, but denied it indoctrinates dependent children. Instead, the children were allowed complete freedom of worship, and the orphanage did not maintain attendance at the church. So this entity wants to house people. It has a religious origin, but there are the people that live at the housing don't have to attend church. They can practice any religion they want or no religion at all. So, you know, the religious nature of the organization is not manifest in the nature of the work it's doing in this particular case. So it is not religious in its nature of what it's doing, as opposed to the school that literally wants to teach the Bible. In Oliver, we found that the state-funded scholarship program allowing parents of students with disability to apply for scholarship for their children to attend private school did not violate the act. Under the legislation at issue, the state would offset tuition at participating private schools through scholarships to eligible students. The state paid the scholarship funds directly to the parent, and participation was purely voluntary. Any private school, sectarian or non-sectarian, was eligible to participate in the program. The court-held scholarship program did not directly fund religious activities. So here we have a program that allows parents of students with disabilities to allow them to apply for any private school. Any private school. And it's given directly to the parents, and so the parents are the one making the decision. So we're cool with that. The program did not disperse funds directly to any private sectarian school until the parent made the private independent selection. So because the parent is the one making the choice, we think it's detached enough to allow for that. So that's fine. Here, there is no question the state will provide monetary support to teach the Catholic curriculum, and students will be required to participate in the religious curriculum. The funding will go directly to St. Isidore, dissimilar from scholarship programs. So here we're just giving the money flat out to the school, right? We're not giving it to the parents who go to the school. We're just giving it to the school. So that's a little bit more direct. All right, and then we could have a discussion about whether or not it's a governmental entity, but the act expressly states charter school means public school. The Oklahoma School Code defines public school as all free schools supported by public taxation. Charter schools must be equally free and open to all students as traditional public schools. They may not charge tuition or fees. Oklahoma charter schools fall within that definition. Yep, no problem. Charter schools are also subject to the same academic standards and expectations as existing public schools. Charter schools receive funding in accordance with statutory requirements and guidelines for public schools. The employees of charter schools are eligible for state retirement benefits that they provide to teachers. The charter school board is subject to the same conflict of interest and continuing education as the local school board. The charter school board exercises oversight on the school. The charter school board has the power to place the school on probation if it finds deficiency. So the government has oversight. The government has control. The government can stop the school from operating. It sounds like a lot of government entanglement to me. All right. Now we could go to U.S. Supreme Court U.S. Supreme Court actions on this point. The Charter School Board in Isidore claims St. Isidore is not a state actor by legislative designation of public school. The argument fails because a private actor may nonetheless be deemed a state actor whenever there's a close nexus between the state and challenge action. The private behavior may be treated as that of the state. So, even assuming somehow they're not a public school for the purposes of Oklahoma law, which they clearly are, they're a public actor within the meaning of the U.S. Supreme Court law. There is a sufficiently close nexus with respect to the state and the action that the private behavior can be deemed to be that as the government. This again is not ambiguous. At least in this case, it's not ambiguous. The U.S. Supreme Court has applied 5 tests over the year. The significant encouragement test, the willful participant in joint activity test, the government control test, the entitlement test, and the public function test. Yeah, we pretty much get there under every single test. So basically all 5 of them. The Supreme Court of Oklahoma says at least 2. I'm pretty comfortable with at least 4 of those. It's no problem. This is a public actor. That's fine. All right. So having decided state law, which, no objection, right? No objection. I mean, you quoted your own constitution, your own state. Seems perfectly reasonable to me. I have no problem with any of that. That seems fine. So we will now discuss briefly, of course, the federal law, which, of course, the U.S. Supreme Court could disagree with because that's their job. So we're now going to discuss the U.S. Supreme Court law. The Establishment Clause prohibits the contract. Does it? Let's figure out. We next look at the U.S. Constitution. Well, we've already found St. Isidore to violate 2 provisions of the Oklahoma Constitution, which affords bona fide separate, adequate, and independent grounds. The St. Isidore contract also violates Establishment Clause. So I would agree that there is independent grounds for this decision. We don't really need to cite the federal law at all, right? There's independent grounds for this decision under state law. So the only really way for the reason the Supreme Court took this up is basically because they're saying, well, we're not sure that you can do that, right? If you could do it, then the fact that you are just right. If the federal government says you can do it, and the state's here's a whole bunch of state level reasons that we can do it. Why does the federal government care, right? Why does the federal government care if the federal government says this is totally cool, and the state says, yes, it's totally cool, but for completely distinct reasons? We don't really like any of those federal reasons. They're dumb reasons. But we're going to do exactly the same thing for completely separate reasons. And the Supreme Court's what the fuck do we care? What the fuck do we care, right? It's You want to do exactly the thing that we say you can do, but for totally independent reasons? Sure, knock yourself out, right? What do we care? You're doing the thing. The U.S. Supreme Court, however, could reverse it as to whether they can do this. So the question is, does the Establishment Clause allow a state to completely nope out of this? Interesting question. So let's read their analysis and discuss a little bit more. Under the Establishment Clause, made binding upon the states through the 14th Amendment, Oklahoma cannot pass laws which aid one religion, aid all religions, or prefer one religion over another. The Establishment Clause prohibits government spending in direct support of any religious activities or institutions. The Establishment Clause also prohibits the government from participating in the same religious exercise that the law prevents when performed by a private party. Thus, the Establishment Clause hinges on whether religious activity involves a state actor or constitutes state action. Okay. The Establishment Clause cases from the U.S. Supreme Court have not dealt with the creation of a religious public school. Rather, the cases have revolved around religious acts in public schools. In Kennedy versus Vermont, the U.S. Supreme Court discussed comparable situations that violate the Establishment Clause, where the court held that requiring or persuading students to spend time in religious instruction was a violation, where the court held that reciting prayers as part of an official graduation ceremony because the school practically compelled attendance and participation was a violence, and where the court has held that broadcasting prayer over the address systematic activities where students were required or expected to participate was a violation. These cases demonstrate that the Establishment Clause prohibits public schools from requiring or expecting students to participate in religious activities. That's a reasonable read of the case law. Because it's a governmental activity and a state actor, St. Isidore cannot ignore the mandates of the Establishment Clause. Yet a central component of St. Isidore's philosophy is to establish and operate the school as a Catholic school. St. Isidore's will fully incorporate Catholic teachers into every aspect of the school, including its curriculum and co-curricular activities. It requires students to spend time in religious institutions activities. We hold that establishment violates the Establishment Clause. Okay, that's pretty sound reasoning, to be honest. That's pretty sound reasoning. And so, let's read very briefly this other case they cite, or at least read part of it. So we'll read this from this case, Everson versus Board of Education. And they cite page 15 of the Supreme Court. So we will read page 15 and see what it has to say. Okay. So here's what the Supreme Court previously said in this other opinion. The meaning and scope of the First Amendment, in 1947, incidentally, the meaning and scope of the First Amendment preventing establishment of religion or prohibiting free exercise thereof, in light of the histories and evils, was designed to forever suppress, has been several times elaborated on by decisions of this court. Yep. The broad meaning given to the amendment by these earlier cases has been accepted by this court in its decisions concerning individual religious freedom rendered since the 14th Amendment was interpreted to make prohibitions on the First Amendment applicable to the state. There's every reason to give the same application and broad interpretation of establishment of religious clause. The interrelation of these complementary clauses is well summarized in a statement of the Court of Appeals of South Carolina, which said, quote, the structure of our government has, for the preservation of civil liberty, rescued the temporal institutions from religious interference. On the other hand, it secured religious liberty from the invasion of civil authority. The establishment of religion clause of the First Amendment means at least this. Neither the state nor the federal government can set up a church. Neither can pass laws which aid one religion, aid all religions, or prefer one religion to another. Neither can force nor influence a person to go to or remain away from a church against his will, or force him to profess a belief or disbelief in religion. No person can be punished for entertaining or professing religious beliefs or disbeliefs, for church attendance or non-attendance. No tax in any amount, large or small, can be levied to support any religious activity or institution, whatever they may be called or whatever form they may adopt, to teach or practice religion. I mean, to be fair to the Oklahoma Supreme Court, I think there's some pretty strong language here that would suggest the Oklahoma Supreme Court is perhaps right on this issue. So, because we're doing it more directly, maybe this is a line too far. Maybe this is a line too far because we're funding the school directly. So if we were making it available to students, as we give them a rebate, right? We give them the rebate and the student makes the choice and the student then transfers the money over. Maybe that's okay. But maybe this is just a bridge too far. It's too direct. Fair point. I think the Supreme Court of Oklahoma has some points. Of course, as I mentioned before, assuming Oklahoma could do this, it would have to be true. They would have to do it on even terms to any and all religion, based on some sort of neutral threshold. So they would have to make it available for any religion that met neutral terms. So, as long as you're comfortable with there being Islamic schools and Jewish schools and Buddhist schools and whatever else people can get together to have sufficient numbers, right? You would have to make this neutral. So that's assuming you can do it at all. It would have to be neutral. We must consider the New Jersey statute in accordance. Oh, I went back to 1947. Sorry, wrong case. Okay. The free exercise clause is not implicated. The Charter School Board and St. Isidore contend the free exercise clause of the First Amendment prohibits the state from denying St. Isidore its right to operate as a charter school solely because it's religious. In support, they point to recent U.S. Supreme Court decisions that held that once a state makes a public benefit available to its citizens, the state cannot exclude religious entities' eligibility solely because of religious affiliation. If so, it does violate the free exercise clause. See, for example, Carson versus Macon, holding the non-sectarian requirement of Maine's tuition assistance program for privately funded schools violated the free exercise clause. Espinoza versus Montana, concluding that state scholarship program for students attending private schools was permissible under the free exercise clause. Citing Trinity versus Comer, holding the denial of grants to religiously affiliated applicants for the purchase of rubber playground services violated the free exercise clause. All they're trying to do is provide some mats, man, for the playgrounds. Who cares what religion they are? I mean, that sounds like a kind of a silly case by comparison to those other two. It's like all they're trying to do is prevent the children from being hurt on the playground. Let the man make the mats, man. The free exercise of trilogy does not apply to governmental action in this case. St. Isidore is a state-created school that does not exist independent of the state. Unlike the private entities in the free exercise trilogy, St. Isidore was created in furtherance of the state objective. I mean, I will give it this, right? This is a significantly stronger tie to state action than we have seen. This is a stronger tie to state action than we've seen in the past. I mean, this is pretty direct, right? So, yeah, this seems, this is pretty direct. The Carson court specifically designated the private schools at issue in that case were not public schools, noting all the difference between public and private schools. St. Isidore further contracted with the state to receive complete and direct financial support for the public school, funding mandated by the act. In Carson, the court noted the state did not cover the full cost of private secondary schools. In Espinoza, the individual receiving the scholarship determined its allocation, not the state. So because it was the parent that made the choice, then it was the parent making the decision. So it was detached enough. But here, this is a little bit closer. In Trinity, the government funded was for non-religious use, playground resurfacing. I mean, that case just seems dumb by comparison. That case seems dumb by comparison. Like, you have these two things which arguably intertwine religion and education. And then you have this third case that deals with playground surfaces. I'm not really sure this third case belongs in the context of the other two. This case is not like the other cases, man. Finally, St. Isidore is not a religious private school or organization seeking to be treated equally with other private schools relative to a tax credit, grant, or tuition assistance. The differences between the free exercise trilogy and this case are at the core of what the case entails. What St. Isidore requests from the school is beyond the fair treatment of a private religious institution and receiving a generally available benefit. It's about the state creation and funding of a new religious school. Even if St. Isidore could assert free exercise rights, those rights would not override the legal prohibition under the Establishment Clause. Compliance with the Establishment Clause in this provision is a compelling governmental interest that satisfies strict scrutiny of the other provisions of the First Amendment. I'm not necessarily sure you even have to satisfy strict scrutiny at that point because it's a constitutional provision. Like, I understand what they're trying to say. Like, they justify, they want to not have Establishment Clause would itself provide any basis for any exception you needed to any other First Amendment provision, but it's just weird phraseology under that. But yeah, I mean, all these cases are super recent. 2017, 2020, and 2022. Yeah, I mean, all these cases are very, very recent. So, I mean, because this has been a change in the law that's happened relatively recently with these programs, and the Supreme Court saying, you know, that the allowance of public money to flow to religion, and you have a couple cases here, but this does seem like a bridge too far. So I think this is a bridge too far. So I think I'm with Oklahoma. But what I will do is I will skim their writ for certiorari, and they can tell me why I'm wrong. So give me a second to pull that up. And we'll figure out why I'm wrong. All right. Let's see why they think the Oklahoma Supreme Court got it wrong. Let's read at least some of this. See what it looks like. Blah, blah, blah. Okay. This court has repeatedly struck down states' attempt to exclude religious schools, parents, and students from publicly available funds based solely on religion. After each ruling, some states sought alternative bases to exclude religious schools. After Trinity, Montana argued it could exclude those based on schools' religious use of state funds. After Espinoza, Maine said it could exclude because of religious schools don't offer a rough equivalent of public education. Thank you for the Guff memberships, Tony. They're appreciated. Now, post Carson, the Oklahoma Attorney General says the state can exclude religious charter schools because the state law labels them public schools established by contract, and that label somehow transforms a privately owned and operated school's religious institution into state action. I don't know, man. I don't know. If this comes down to whether or not this is state action, I think they're doomed. How can this not be state action, man? Right? I mean, how can this not be state action? You've got a state board and a state act and a state everything, and it's a public school, and like it's being. I mean, how is this not state action, man? Yeah. I mean, you could have your religious school and it would be fine if you just want to run it yourself. Run it out of the diocese. You can have your Catholic church. There are a lot of Catholic schools. Some people really like Catholic schools. You can have your Catholic school, just run it out of the diocese like a normal school. But you want to specifically run it out of the state, man. And then you're bitching that you're being treated like a state actor. If this turns on whether or not they're a state actor, man, I don't see how Oklahoma can win. That seems like, or apologize, so the school can win. I don't see how the school can win if this turns on whether or not they're a state actor. Holy shit. The Oklahoma Supreme Court accepted that argument, holding a charter school as public school. So this court's exercise trilogy did not apply to governmental action. Oklahoma can now exclude sectarian charter schools, even privately run, statewide virtual charter school. Well, yeah, because they're funding you directly. That's sort of the problem. That ruling violates this court's recent cases. And the underlying state action ruling implicates a circuit split. I don't know, man. The Oklahoma Charter Schools Act authorizes most private organizations to establish charter schools by contracting with its sponsor. But not all private organizations are eligible. Religious institutions need not apply. Right. You're not allowed to be in the state. Right. The Act seems to encourage the use of different and innovative teaching methods, providing additional academic choices for parents and students, and establish new forms of accountability. To achieve these goals, the Act exempts charter schools from all statutes and rules relating to schools, boards of education, school districts, except in limited circumstances. So, yes, they're public schools, but they're public schools under a different system. Right? The whole purpose of these charter schools was to get out of the normal rules relating to school boards and school districts and all that bullshit. Right? That was the whole point. But they're still public schools. They're just operated under different rules. Which, you can have more than one system of rules. And the charter schools, at least as far as I can tell, have been reasonably successful. And people seem to like them on the whole. So it seems like it's working as far as I can tell. They're public schools. They're not subject to the normal rules. They're subject to new and exciting rules. Fine. You can have new and exciting rules. That exemption means charter schools do not need to follow the state's core curriculum requirement, and they may offer curriculum which emphasizes a specific learning philosophy or style of learning or certain subject areas. Okay. The new and exciting public schools are not bound by the standard curriculum. Noted. Nor must charter schools follow the state's teacher and leader effective standards, nor hire teachers with a valid teaching certificate. So you're more flexible in who you can hire. Okay. Fine. I don't really know how any of this has to do with anything, right? It's like the state's like, we'd like some new exciting rules. You don't have to follow the standard curriculum. You don't have to follow standard hiring practices. But you're funded by the government, man. It's like, so it's just like, okay, you're a state school. Oklahoma charter schools have their own governing bodies. They're responsible for their policies. Okay. And they hire their own personnel and adopt policies of their own. Cool. The Act requires charter schools to comply with all federal regulations relating to health, safety, and civil rights, and charter schools must be as equally free and open to all students and must not charge fees. Fine. I don't know how this seems like off point to me. All state funding that a charter school receives under the Act depends directly on enrollment. As the Act explains, a charter school receives the state aid allocation and any other state appropriate revenue generated by its students. For virtual charter schools, state aid comes in two forms: foundation aid and salary incentive aid. The full amount of foundation aid and salary incentive aid that a virtual charter school receives is based on pupil count using average daily membership method of counting. That method begins with the charter school's first year with the school's actual enrollment of students, and the number is subject to adjustment based on change. Based on the number of enrolled students in the school is a requisite component of the calculation. All right, so they're trying to basically say that the parents are funding that. I don't know, man. I don't know. In 2012, the Oklahoma legislature created the statewide virtual charter school board, giving it the sole authority to sponsor statewide charter schools. Cool. So instead of there being multiple school districts and each school district basically creates the schools and runs the schools and the Department of Education and all kinds of other bullshit, right? Rather than that, we basically have one ring to rule them all style. We have this new exciting organization, which is now the master of all these schools on a statewide level. So we're reducing the bureaucracy. Okay, noted. The Act authorizes the board to establish a procedure for accepting, approving, and disapproving applications. If the board approves an application, the board and its application negotiate and execute a contract. The contract incorporates provisions of the charter. And the charter itself includes a description of personnel policies, personnel qualifications, and methods of school government. Again, they're allowed more flexibility in their rules, which was, again, the point. Right? So, you can have more flexibility in your rules. You can have more flexibility in who you hire and how you fire them. And, so you're not like the other public schools. I mean, there's that, but, So the rules are more kind of whatever they want to agree to. It's like, okay, but you're still a state school though, because the government is the other end of this equation, right? It's like, yes, you and the government can agree on the terms of your school, right? But you and the government have to agree. So it's the government. It's like, okay. The sponsorship contract all addresses admission policies and procedures, management and administration, and how the charter school will comply with the requirements. And while the board provides ongoing oversight, each school governing board is responsible for the policies and operations. Well, no shit, Sherlock. I mean, that's kind of true of normal schools. Yes, on a day-to-day basis, the schools are kind of in charge. And then, like, other people are in charge, when they fuck up. And even in public schools, the state can overtake the schools, which sometimes happens. Right? Sometimes the city fucks up so hard and the state takes over the school. But like, yes, I mean, on a day-to-day basis, the schools do their thing, and then there's oversight authority. And this particular oversight authority can also shut you down. So they can do that. All right. St. Isidore is privately organized to serve as a Catholic school. Yeah. I mean, the school has two private members, the Archbishop of the Archdiocese and the Bishop of the Diocese. I mean, seems like they might be religious. Yeah. So blah blah blah. Blah blah blah. The charter board approved St. Isidore's application. We know that because we read that in the court below. Respondent sued. We know that because we read it below. This Oklahoma Supreme Court assumed original jurisdiction and issued the writ of mandamus. Okay. On the state law question, the court held a whole bunch of things, which the Supreme Court literally can't review, so we'll ignore all those things. Though St. Isidore is privately owned and operated, the court held that it is a governmental entity. Looking first at the statutes, the court observed that the legislature labeled it as a public school. Oklahoma also imposes on charter schools many of the same privileges, responsibility, and legal requirements that govern traditional schools. Well, even if they hadn't imposed literally one requirement in common, it wouldn't matter. That's kind of a silly argument, right? Right? I mean, it would be a little bit strange, but like, I mean, like literally, if Oklahoma said, you know what, we're going to create a completely separate school system, and not one single goddamn requirement of this typical school system applies to this new and exciting school system. We have new exciting rules for you that are completely independent of the old exciting rules. Here's your set of new exciting rules. Like, the commonality of the rules doesn't really matter, right? I mean, to prove that point, you could, at least in principle, have a private school that for whatever reason just adopts all the rules of a public school. I mean, I'm not sure exactly how that works in this hypothetical, because I'm not sure how the private school like submits itself to the state in that respect, but you could like at least try to, right? I mean, you could do a 1-for-1 match on the curriculum. You could do a 1-for-1 on hiring practices. You could kind of just copy things as much as you want. But like, if the private school like tried to copy as much things as they wanted, it's still their choice. It doesn't magically transform them into a public school just because their policies are the same. And even if you have completely distinct policies, it doesn't mean that you're not a public school. It's a very weird thing. The court concluded that charter schools are intertwined with the state because governmental entities sponsor them, monitor, and oversee their operations, and decide whether to review or revoke their charters. The court declared that while the provisions of education may not be traditionally exclusive public function, the Constitution provision for free public education is a public function. The court dismissed this court's decision in a similar case. There, the court held that a privately owned and operated school was not a state actor, despite extensive government funding and regulation. Yeah, I don't know, man. I don't know. It feels pretty. And there's also no like pinpoint site. Well, they do cite 842. All right, give me a second. Let me pull up this other decision at 8:42 and see what the hell it says, because it doesn't feel right. It doesn't feel right. My spidey senses are going off. So let's read it. All right. This is Rendell Baker versus Cone, Supreme Court 1982 rather. 457 U.S. 830, reading at 842. The third factor asserted to show the school is a state actor as it performs a public function. However, courts have made clear the relevant question is not simply whether a private group is serving a public function, right? Because you could have a private police force, you could have a private police department, you could have a private ambulance service, right? You can have a lot of private entities that perform public functions, but do it on a private basis. We've held the question is whether the function has been traditionally the exclusive prerogative of the state by mere fact of performing the function, right? Mere fact of performing the function. So but this not merely performing the function, right? So no, I don't think anyone's contesting this point, right? We're not contesting that there can be private schools. We're not contesting that that education is exclusively state. So I don't think this is on point. There can be no doubt that the education of maladjusted high schoolers is a public function, but that's only the beginning. The relevant law of Massachusetts demonstrates that states intend to provide services for the students at public expense. The legislative policy choice in no way makes the services exclusive province of the state. Mere funding does not. Mere funding typically does not. Indeed, the Court of Appeals noted that until recently, the state is not undertaking to provide education for students who could not be served by traditional public schools. That the private entity performs the function does not make it a state actor. Right. So merely funding does not alone constitute typically state action, because the government can contract for stuff and it doesn't normally make the private entity a state entity, because that would be really stupid, right? That would be really dumb. So yeah, that case is off point. Yeah, I don't like that citation. That case, I don't agree with that citation. Yeah, it's a lot more than just funding. And also, it's funding of specifically a religious entity to provide religious education. Which is a little bit much. In this other case, let's see what was going on real fast. I have to speed read this other case to figure out what's going on. It's a reimbursement of parochial students. Rules and contracts for transportation of students. Payment was for transportation of children to Catholic schools, for school buses. Yeah. Blah, 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 blah. Still speed reading, blah, blah, blah. Yeah, this seems like it's off point. Yeah, I don't like this decision. I don't like the citation of this decision. It feels off point. The court held that because St. Isidore is a governmental entity, its contract violates establishment clause. The court held that excluding St. Isidore does not implicate the free exercise clause. Yeah. I think I'm with the Oklahoma Supreme Court on this case. Yeah, I think I'm with the Oklahoma Supreme Court on this case. Yeah, it feels like too much. It feels like too much. It feels like a bridge too far. Yeah. I think I'm with the Oklahoma Supreme Court on this one. So, yeah. Plus, I'm pretty convinced personally that the moment someone tried to open a Islamic school or Buddhist school or whatever, people would lose their mind, because we've seen that before. We've definitely seen that before with people losing their mind when it's been tried to be equal. There's cases on that point, right? It's like people lose their absolute mind. Sometimes watching the religious people get hoisted on their own petard is kind of hilarious. You know? Yeah, my personal favorite one. I think my personal favorite example, I think it was the Satanic Temple, although I wouldn't swear to it. I think it was, though, which sometimes can do some great trolling, though. There was a school that had this thing called backpack mail, like an elementary school. There's a thing called backpack mail. The school would, give out flyers and stuff relating to school functions for kids to take home. And people wanted to include private things in there as well. And so the school started to do that. I think initially it started with like sports leagues and stuff, right? So like, oh, by the way, there's this private entity, there's this private baseball thing, there's this private soccer thing, there's this private whatever thing, there's this karate thing, to make parents aware of things that were being offered that their kids might be aware of, interested in, which, fair enough. Some Christians wanted to include information, I believe it was relating to Christian camps. I forget if they were day camps or summer camps. It doesn't really matter. But they wanted to include information relating to the camps. The school said, no, this is religious. We're not going to do it. The Christians sued. And the court said, well, look, the teachers don't have any discretion here, right? The teachers don't have any discretion. It's just, it meets all the requirements of the thing. The teachers just put it in the envelope. It goes home with the kids. So that's fine, so you can do that. No problem. You can do your mail. And, all the Christians celebrated. And then I'm pretty sure it was the Satanic Temple, because they do some world-class trolling, who I think provided flyers regarding their own Satanic Temple camps. And of course, what happened? The Christians sued. This is like, you can't have that mail. And then it's like, wait a second. No, yeah, they absolutely can. Did you not read the decision that you got us to establish? Did you not read that, because this is being done by the school and because they do it, all the rest, that the logic worked. And so I believe in the end, they wound up killing the entire thing. They wound up killing the entire backpack program because, the Satanic Temple trolled the Christians so hard. So, yeah, good times. The Satanic Temple also has a satanic coloring book where you can paint by numbers, like, Bahamut and stuff, which I think is also slightly hilarious. So they're master trollers, but they're very, very good at it. Wasn't there a Krishna statue as well? I don't remember that. It doesn't sound like the same case. There might be a different case with a Krishna statue. That sounds plausible, and I don't know the degree to which that would be a problem or not. But yeah, that's possible. Krishna statue, not statute, right? I understood what you mean, and I might have mispronounced it, but statue, I understood what you meant. I might have said it wrong. Yeah. 10 Commandments is an interesting use case, and you get into some interesting stuff with that, with a more historical stuff in there, but it's not important right now. So it'll be interesting to see when the Supreme Court takes this up. No decision yet as to when the oral argument of this case is going to be, but I think it's a pretty interesting case. Let's see if there's anything else coming up that looks interesting. Where are we now? It's late January. What is coming up at the Supreme Court? We could do this Supreme Court oral argument reaction. That was pretty interesting. Barnes versus Felix. We might do a Supreme Court oral argument on this. I don't think today, but dealing with when the police shoot somebody, what time frame do we evaluate it in? That's a pretty interesting case. So what time frame is important when you're assessing that? Let's see what's coming up in February. Smith and Wesson versus Mexico, dealing with whether or not Mexico can sue the United States for firearms. That could be fun. Ham versus Smith, decided without oral argument. So this is death penalty though. Oh yeah, it's a 2-page per cur death penalty case. Right, so we can read this decision real fast. It dealt with the death penalty. There was a decision on this case. Ham versus Smith. 2 pages. This is decided in November. Joseph Clifton Smith was sentenced to death for murder of Dirk Van Dam. The District Court for Southern District of Alabama vacated the death sentence after concluding he's intellectually disabled. Smith has obtained 5 full-scale IQ scores ranging from 72 to 78. Smith's claim of intellectual disability depended in part on whether his IQ is 70 or below. The District Court found that Smith's IQ could be as low as 69, given the standard error for measurement of his lowest score of 72. The District Court then vacated the death sentence, and the U.S. Court of Appeals for the 11th Circuit affirmed. Analyzing Smith's intelligence function requires evaluating his various U.S. IQ scores. In Hall versus Florida, this court has stated that where a person has taken multiple tests, each separate score must be assessed, considering the standard of error measurement. The court further noted that the analysis of multiple IQ scores jointly is a complicated endeavor. This court has not specified how courts should evaluate multiple IQ scores. The 11th Circuit opinion can be read 2 ways. On one hand, the 11th Circuit opinion might be read to afford conclusive weight to the fact that the lower end of the standard error range is 69. This analysis would suggest a per se rule that the lower end of the standard error range for an offender's low scores is positive. On the other hand, the 11th Circuit also approvingly cited the District Court's determination that Smith's lowest score is not an outlier when considered together with his other scores. That analysis would suggest a more holistic approach to mobile IQ scores that considers the relevant evidence, including as appropriate any expert testimony. The 11th Circuit opinion is unclear on this point, and the court's ultimate assessment of any petition for certiorari may depend on the basis for the 11th Circuit decision. Therefore, we grant the decision for certiorari and remand for further decision. So the U.S. Supreme Court's not quite sure what the 11th Circuit said, and it's like, could you please try harder to be a little bit clearer on this, because we're not quite sure what you meant. So try again. Try again, 11th Circuit. Let us know which one you thought. Is there anything else coming up? That looks interesting. Whether the Promoting Security and Justice for Victims of Terror Act violates due process. Nothing else is jumping out at me, screaming at me. A lot of stuff that's very technical. I don't know. This docket seems like a little bit, the court's docket this year seems a little bit low on the really exciting stuff. This court's docket's, I mean, not to say there haven't been a few ones that have been exciting, but it feels a little bit lower on the really fueled cases this year. I don't know. Maybe it's just me or my expectations, but whatever. When the district court clarifies, does it go immediately back to the Supreme Court? No. The Supreme Court's like, we don't know what to do. Right? So it was a petition for cert. And it's like, we're not quite sure what you said. So in order for us to decide whether or not to take this case, could you clarify this point, please? So, but it's still up to the Supreme Court to take it or not. They're just like, we'd like a little bit more clarity in your decision about what exactly you're saying. So, yeah. If I could write and pass a constitutional amendment mandating time limits for constitutional amendments, would I do it? Yes, I think so. I think I would. I'm kind of hungry. Religion school or religious schools? Religious, I think, is better. Or I think religious school is probably better than religion school. I think it's going to end up being Taco Monday. That's a good call. Tacos does sound nice, actually. Yeah, tacos sounds nice. I think I'll go get some tacos. I've been feeling really weird the last couple days. By the way, my mom is doing fine-ish. She's still in the hospital, but it seems to be like not critical. So I'll talk to her again today, but it seems like things are going okay. So, but I think between the fact that my mom is sick, my mom is in the hospital for blood pressure. By the way, for those of you who are not familiar with this, my mom has been having blood pressure issues and has not been able to treat it despite multiple doctors and medications and so forth and so on. So, and it's currently in the ICU. I think partially because I don't think they have beds to get her out of the ICU into, but whatever. But I think it's made me. I think I've been depressed. And I think feeling lonely. I've been feeling very lonely. I need a wife. That's what I need in my life. I need a wife. Having someone to take care of, is meaningful. Having someone to take care of is meaningful. All right. Well, I'm going to sign off for now. I hope all is well. Until later, my friends. Cheers and goodbye.